Today's trial court decision finds that the Lane County Board of Commissioners violated the Oregon Open Meetings Law. Specifically, the decision states that 4 out of the 5 Lane County Commissioners then in office violated the law. Of these 4 commissioners, 3 still currently serve on the board: Commissioner Stewart, Commissioner Handy, and myself. I respectfully disagree with the trial court decision. To be clear, I have fought for and believe in open government. That's why I've pursued a good government board order here at Lane County. It's why when I was board chair in 2009, I pushed for and held more public meetings than the board has held in many years. These meetings with many groups who've previously been left out were productive and helpful. I want to assure Lane County residents that I conduct myself now and at all times in the past in accordance with Oregon's laws, and in particular the Open Meetings Law, which states that decisions affecting the public must be made publicly. My understanding is that today's decision is that a violation occurred not when Commissioner Handy met Commissioner Dwyer to discuss the amended budget in 2009, but when he met Commissioner Stewart on a separate but subsequent occasion, even though a formal public meeting was later held. I don't think any of the commissioners violated the law, as there was never a quorum of the Board of Commissioners present during any of these meetings prior to the board's decision. Thank you.
Thank you, and thank you everyone for coming today to hear my statement regarding the surprising ruling by Judge Gillespie in the lawsuit filed against Lane County and its commissioners by Dumdye Anderson and with the support of Seneca Sawmill. Today's ruling was a mixed bag and pretty surprising in apparently forming new case law and holding elected officials accountable to a standard that does not meet current Oregon law, although this ruling may change that. I was happy to see that the judge rejected the actual complaint that Commissioners Fleener, Sorenson, and myself had participated in illegal quorums in violation of Oregon's public meeting law. He did not find that to be true, and that is one vindication. I'm very pleased with that decision, although I am afraid that this fact will be lost in other parts of the ruling. I want to emphasize, however, that this was the basis of the lawsuit and that the plaintiffs offered evidence of this and that Judge Gillespie ruled in our favor on this issue. That part feels great. I am a firm believer in transparency in government and feel that Judge Gillespie based his ruling at least in part on my working in the open for something that I believe in. From my first month in office, I became convinced that a commissioner could not offer adequate response to constituents and conduct all the other duties necessary of a commissioner without help. I was not and am not willing to not do a good job. I've been very upfront about this need. It is a relatively small amount of funds with a large benefit for the county. I have talked about this issue in budget committee meetings, commissioner meetings, in op-eds, and with individual commissioners, and indeed with anyone that has an interest. I took considerable political heat for this and publicly stood by my belief. I call this transparency. You may or may not be aware that within the 41-page ruling today that Judge Gillespie found 4 commissioners, Commissioners Stewart, Sorenson, Dwyer, and me, in violation of Oregon's public meeting law. He stated that we were in violation by simply talking to each other one-on-one. This is the surprise ruling, and I think a surprise to all elected folk within the state, and is clearly an unprecedented and broad interpretation of Oregon's law. Obviously, none of us believe that talking one-on-one or even trying to persuade each other one-on-one is against the law. It is actually common practice. Again, Judge Gillespie found Commissioner Stewart, Commissioner Sorenson, Commissioner Dwyer, and me in violation of Oregon's law simply because we talked one-on-one regarding the issue of constituent assistance in the days preceding the December 2009 supplemental budget decision. I still don't believe that talking to another commissioner one-on-one is against the law. I was clearly informed by legal counsel and commissioners of the past and present what behaviors are allowed within Oregon's law, and have followed that advice and the precedents set by the commissioners before me. We will be looking tomorrow and in the future at whether we will appeal this. My personal feeling is that we should. I fear that leaving this ruling intact will set up a huge barrier in necessary communication between colleagues and change government by hampering the ability of elected officials across Oregon to conduct business. In my opinion, it has gone too far. I am disappointed in the ruling for that reason above all. I think today's ruling was a mixed bag. I'm happy that the judge did not find commissioners broke Oregon's public meeting law through illegal quorums. I am surprised that his ruling goes above and beyond what is considered Oregon's current law. And I am saddened that he found 4 Lane County commissioners, Stewart, Dwyer, Sorenson, and myself, in violation of the law because of holding one-on-one conversations. And I am ready to consider what we may do in response to this ruling, and we'll start that discussion tomorrow. Most of all, I look forward to getting back to the work of Lane County government. The true story, the one deserving all of the attention of the commissioners, the public, and the media, is that Lane County is facing a severe fiscal crisis while the people of Lane County are enduring much in the face of great economic hardship. That should be the story of the day. But I realize that this is the story of the moment. Thank you all for coming today.